The Southern District of New York is nicknamed the Sovereign District of New York because of its reputation for standing for the rule of law. And we are seeing that in real time as the acting U.S. Attorney in Manhattan, Danielle Sassoon, stood up to Donald Trump by announcing her resignation today after refusing to allow a DOJ order to drop the corruption charges against New York City Mayor Eric Adams. Mind you, Sassoon is no liberal, deep state prosecutor by any means. Quite the opposite. She was a member of the Conservative Federalist Society and once clerked for the late, very conservative Supreme Court Justice Antonin Scalia. And she was appointed by Trump to the acting position just a few weeks ago. While she did not refer to the Adams case in her brief resignation statement, NBC News has obtained a letter from her describing the DOJ order as being part of a quid pro quo. Quote, I attended a meeting on January 31st, 2025 with Mr. Beauvais, Adams' counsel, and members of my office. Adams' attorneys repeatedly urged what amounted to a quid pro quo, indicating that Adams would be in a position to assist with department's enforcement priorities only if the indictment were dismissed. Mr. Beauvais admonished a member of my team who took notes during that meeting and directed the collection of those notes at the meeting's conclusion. It should be noted that she's not alone in standing up to the Trump administration. Numerous top prosecutors and senior members of the DOJ resigned when asked to take control of dropping the Adams case, including Kevin Driscoll, the acting head of the department's criminal division, John Keller, the acting head of the agency's public integrity section, and at least 3 other senior members from that section. Joining me now is Paul Butler, MSNBC legal analyst and a former federal prosecutor, and MSNBC legal correspondent Lisa Rubin. Lisa, you were in front of that courthouse today, so I do want to come to you first. I read through Mr. Beauvais' letter, his very angry letter. Paul and I were talking in the break about how you could almost hear him angrily typing, right? And this is what stood out to me. And you and I both observed Mr. Beauvais when he was the lawyer for Donald Trump in the hush money case. Y'all have to remember, he was Donald Trump's lawyer during the hush money case in New York that he lost, okay? This line stood out to me, Lisa. On February 10, I directed you to dismiss the prosecution of Mayor Adams based on well-founded concerns regarding weaponization, election interference, and the impediments. This is an important part. That the case has imposed on Mayor Adams' ability to govern and cooperate with federal law enforcement to keep New York City safe. He goes into greater detail on that later. I feel like he's admitting that they're dropping the case because it would impede Mayor Adams' ability to help them with immigration enforcement. To me, that proves Ms. Sassoon's case, does it not?
Well, Joy, ML Beauvais essentially admits as much in the February 10th letter that they sent to Ms. Sassoon directing her to drop the case. Basically says in that letter, we're not making an assessment of the evidence that you have or even the legal theories on which you've based this indictment, nor am I impugning the integrity of you or the line prosecutors who have brought this case. Rather, I'm directing you to drop it based on 2 considerations. 1, the timing of the election vis-a-vis the indictment and the trial date. And 2, because this indictment hanging over his head is an impediment to his devoting his full attention and resources to the problems that are priorities for us, including violent crime and immigration enforcement. So it's not a surprise that he is saying so again in this February 13th letter to her, because that's essentially what he said in the 2-page memo he sent her on the 10th, directing her to drop the case. I will note to you that in her own letter to Attorney General Bondi on the 12th, she refutes that. She says, look, the deal is conditioned on his accepting a dismissal without prejudice, which means that the case could be brought again after the November election in New York City for its next mayor, when we have a Senate-confirmed U.S. attorney here. She says it really makes no difference whether it's hanging over his head as a possibility of a future trial or there's a trial date in the near future, which, by the way, he asked for that trial date. But she said it really makes no difference. 6 1 half a dozen the other, he still has that possibility hanging over his head. How that impedes him from participating in immigration enforcement or how he's better able to participate in it under your conceived deal, I don't really understand, Mr. Beauvais, she writes.
Yeah, and it means he's on a leash, Paul. I mean, it means that he would be under control because then she implies this in her letter, which I have here as well, that essentially he would be constantly monitored for compliance with the administration's wishes. So that I find alarming. Also, this reinterpretation of how you uphold your oath to the Constitution, at least in this letter by Mr. Bovee, I don't know how I'm pronouncing his name, is that you must adhere to what the president wants in his policies. I'm not a lawyer, but I don't think that's what the Constitution says.
It doesn't say that. There is a chain of command that if the Attorney General is the boss, including of U.S. attorneys. So if the Attorney General tells you to do something, you are supposed to do it. But Sassoon didn't say she wasn't going to do it. She resigned, understanding that it would be in conflict with her ethics, her morals, and the reason that she became a prosecutor, which was to fight the bad guys. And now it looks like the bad guys are the people who she is supposed to be working for. So that was a bridge too far.
She said, Lisa, in her letter, essentially, that when I took my oath, which Donald Trump appointed her to, she said that I was told that we were not to use our office for political purposes, to boil it down, and that doing this is using it for political purposes. You actually predicted that this might happen yesterday when you were on with our good friend Nicole Wallace, because it didn't seem to be that she could do what he's asking her to do, as Paul said, and still uphold her oath to the Constitution, not to Donald Trump.
Well, and not only does she have an oath to the Constitution, Joy, but in her letter to the Attorney General, she goes through some of the other impediments that she thinks that the directive would impose on her, including the fact that an attorney has certain obligations under law in New York. She says basically an attorney is required to tell the truth at all times. There's a duty of candor under law in New York that I would have to violate if I carried through your order. And then she also says, I cannot capably lead this office or appear in court under the circumstances that you've imposed on me. I cannot credibly, I'm reading from the letter, cannot credibly represent the government before the courts if I seek to dismiss the Adams case on this record. In other words, this office prosecutes thousands of cases every year. What are the judges of the Southern District of New York, all of whom are presidentially nominated and Senate confirmed? What are they going to think of me and the line prosecutors, almost 200 of them, that report to me or to the Senate confirmed U.S. attorney, going to think if we get rid of this? We agree to prosecute cases without fear or favor. That doesn't mean special treatment for people based on some perception of what their duties are and how you want them to cooperate with your administration's public policy priorities. That's not what I signed up for.